Estate planning is generally going to be appropriate for anyone who lives in the United States and has property or minor kids here. But the types of planning that we do can vary based on citizenship or status. Generally, if you are a U.S. citizen or a permanent resident, meaning you have a green card, the estate tax threshold, the exemption before estate tax is actually due, is equal, and it currently is nearly $14 million per person. But if you are a resident of the United States and do not have legal status, meaning you're here either on a visa or with no documentation, then the estate tax exemption is only $60,000. And so the consequence of wealth transfer from passing away here as a resident here without status is quite significant. There are planning tools that we can use between spouses where one is a citizen or a permanent resident and the other is undocumented, to make sure that we mitigate that tax as much as we can. When we have immigrant clients in the United States who have property in another country, we're often required to make sure that we plan accordingly in the other country. Estate planning is something that is more common in common law countries, meaning they came from the UK or other colonies of the United Kingdom. It is not very common in civil law societies like everywhere else. But anything that we create is going to be bound by the laws where the property is located. So if we have land in another country, we want to make sure that we have an estate plan or some sort of will analog in that country.